Alrighty, good afternoon, everybody. Going to um, put together a little special presentation today on markets. So if you're joining us, joining me during this presentation, you've been requested to do so by a constituent. The reason for setting this all up is because of a word specifically related to markets. Okay, that's what we're going to discuss today is markets and how a lot of these things play together in the models. So let's start with what constitutes them and why. Okay, so as you can see, my name is Christopher E. Hallett. I am Chief Executive Officer of eClause LLC, Loss Prevention. And the manual with which I do business is the same manual used by the congressional offices of roughly about 70% of the states in the United States. So kind of give you an idea of where the basis of my operations come from. So moving forward, we're going to go with what would, for example, under Sixth Amendment due process, a court recognize as discovery. Well, we'll utilize inevitable discovery. I was working with certain group of people. I won't go into any specifics, but was requested to basically do a short form audit, if you will, on government. So the first place for me to start is with my oath of office. Now, in the term of inevitable discovery, even in the Sixth Amendment due process, it's that basic Magna Carta due process, by the way. Inevitable discovery is defined as follows. It's an exception to the fruit of the poisonous tree doctrine that states that challenged evidence is admissible if the prosecution can show that the evidence would have been inevitably discovered, even in the absence of the police illegality, if there was such an issue. So because this is a word, emoluments, it's in law, the Constitution, and it has my name on it here. That makes it a constitutional provision. Well, as you're well aware, according to the book, constitutions stand on a higher plane than statutes, and those are mandatory. So if you've not looked at the book, that's section 7 in Mason's manual. I believe that is page 16, if memory serves. So we'll move forward here a little bit. So as we go into this, right, how is it that I recognize the relationship between emoluments and the private sector? Well, if we go back to what we know as a de jure republic, right, we can look at the things of and where we work in the private sector as market, margin, and capital, right? That's our market advantage, which is how much of any given market you control at any given time. It's profit advantage, or it's profit margin, obviously. And then, of course, the number that many of you as legislators look at, which is the capital gains, because that's where most corporations are taxed. So, but this is basically the historical dictation of a free market and self-governance, right? Meaning rules of law. Well, the Mason's Manual is the foundations, right? The theoretical foundations we use to establish rules as we move along. So, markets must work within margins established by the Constitution, which is the supreme law, or up, and minimum standard of due process, or down. So those are the two red lines. That's where you hear a lot of people, what's the up and down on that? What they're specifically talking about is the margin, right? How high can I go, or how low can I not go? Okay. And within this margin, you have the state constitutions is basically the guide we use in commerce. Okay. Certain terms you've heard recently are quid pro quo and reciprocity. Well, that's the what for what. And the reciprocity, of course, is the return or returns on your investment or investments. So now that we've established where markets work, right, they have to work within the margins. Okay, it's equal exchange. So this is how, right, we view this on the postal roads, right? Not shipping lanes, it's streets and highways. We're talking postal roads. Again, a constitutional provision. What establishes postal roads? That's Congress. That's you guys. So, and of course, girls. But so, as defined from the law dictionary, quid pro quo is an action or thing that is exchanged for another action or thing of more or less equal value, substituted, right? The discount was given as a quid pro quo for the extra business, right? So what's the extra business? You see reciprocity. Well, I'm going to take you to definitions numbers 1 and 2 primarily because I'd like to not get into intellectual property because, I mean, we're talking the law, right? The common law, what's common to all. So pretty much you can't even patent the law. I mean, it is what it is. It belongs to the people. So within this instruction, okay, as E-clause is incorporated, right, mandatory or oversight is, of course, mandatory. So your mutual or bilateral action is that oversight, okay? So definition number 2, the mutual concession of advantages or privileges for purposes of commercial or diplomatic relations, okay? So what that basically means, right, there has to be an equal exchange, right, between goods and or services and whatever labor is placed forth, right? Because maintaining a reciprocity is certainly labor intensive. So as we move through this, I'd kind of like you to keep on to this thought process. How do we maintain the reciprocity, right? We've established the what for what. So now we have to keep these markets going, right? So one such example, excuse me, rule of thumb that we utilize every single day is what this body of law here known as the Hobbs Act. Okay, this is kind of the example of what not to do because you can find yourself in trouble, right? So just as a short example, we utilize the term property, right? Defined as follows. So the term property includes money and other tangible and intangible things of value. Okay, you're going to hear a lot of people referring to those intangibles as their rights, right? Whether they are enumerated or unenumerated. For example, in the state of Florida, we actually have an enumerated right under our Constitution, Article 1, Section 6, which is the right to work. Okay, so kind of give you an idea of the application of a constitutional provision. So anyway, now we're going to get into markets, what constitutes them and why. So now we've established the margins, right? Now the markets have to work within those. So again, modeled here as the base of the economy used to conduct business, right? So as you see, everything that is outside the triangle, that's jurisdiction 2 in commerce, right? Jurisdiction 1 being defense, right, within the color of law, right? So my defense is many of you will have probably seen a copy of the document. If you wish to reach out to me, my contact information is on there. I'll be more than happy to go down through that with you and how it's applicable. Because remember, we have a cleanup to do, right? We have things that have weaseled their way into our government that don't belong there. So our job is to go in there and clean up the mess. Even Justice Gorsuch recently has said it's only a republic if you can keep it. So let's do that, shall we? Because we're talking about the difference between what is legal and what is lawful. Okay, because those are two different standards. So To examine the word, okay, we start with the upper left corner. That's its etymology, okay? What's right below that is the definition I took from Black's Law, which is the 10th and 11th editions, by the way. So those are in its singular form, okay? And if you remember from my oath of office, it says privilege or emoluments, plural. Okay, so that's when I say, what emolument are we talking about? Are we talking about advantage, profit, and gain? Because in so much as the research, according to this office, it is those three elements that are the only lawful provisions within the republic. For example, in under the fourth pillar of emolumentum, it's profit, gain, advantage, and benefit. So, excuse me, in terms of a contract, okay, who's benefiting and why, right? Or is it an equal exchange? So, in the context of markets in commerce, this is how businessmen and women perceive what a benefit would be. Okay, so now if you notice that the bottom definition is, this actually came from Merriam-Webster's 11th edition collegiate dictionary. And if you see definition 2, under archaic, it refers to the corporation capitalized as advantage, right? I'm sure you're going to be hearing a lot about dog Latin and those types of things. So I won't even bother with going into all that. So, but just so you know, this is the fundamental basis of where these instructions are going to be coming from. So, you know, again, as a member in the committee or Congress, you should certainly be able to verify that. Well, again, as we go through the law dictionary, right, to know a thing and to be bound to know it are regarded in law as equivalent. Okay, so again, as a person in position of emolument, I'm bound to know these things. Well, one of the things I'm bound to know is, notice the lack of a definition to Article 1, Section 9, Clause 8 within the this definition called emoluments clause. Now, here's where it starts to get a little sticky, because the first definition, emolument in its singular form, okay, the second definition is emoluments as it appears on my oath of office in its plural form. Okay, so when we go into foreign emoluments clause, this was something that it never really had to be brought before the court before I got involved in this audit, this government audit. So, so basically the question becomes, where in the Constitution does it say government can create or increase markets? And the answer is, that's not even there. That's for we the people to do that, hence the preamble. So, in so much as oversight, your job is to look for things that would constitute an emoluments violation, something that would cause injury or harm to the people. Okay, that's the benefit to the people of having government. So there's where your fourth pillar would apply. This office I have created a what we utilize in the private sector is a litmus test utilizing this basic science known as coordinate geometry. It's basically, it's two number lines. It's again an up and down, okay, positives and negatives. So the x-axis is the horizontal line and the y-axis is the vertical line. So as we go forward, okay, this is literally the science behind the litmus test that you're looking at and why the equations read the way they read. Okay, so now as we go through and we examine, right, utilizing the legal principle of time rules events, right, that's a lawful principle, excuse me, as you move through time. Okay, as you move through time, and then in our society it's from left to right. Okay, what's the up and what's the down? And mathematically, to measure these things, to factor them out individually, okay, you'll see I've just created just a simple, math equation, right? Um, Emoluments is equal to the quantity of profit plus gain divided by advantage, right? And then, of course, so on and so forth. Now, if you, in the context of order of operations, knowing that there are only four: addition, subtraction, multiplication, and division. So when we convert from profit plus gain and we magnify that, which would be profit times gain, okay, now you're getting into criminal process. Basically the cause of the thing causing is the cause of the effect. The effect becomes magnified, right? The negative effect becomes magnified. So excuse me, the up and down would tend to change, right? Would the up go up and the down go? We know the down would probably go way down because that's just how markets are. But would there be any increase to coincide with the decrease? And the answer is historically no. So kind of as we go through this, when you open your book, there you have 10 basic principles of group decision making that you follow. And of course, it's probably going to be very difficult to read them here, which is why I hope you would have your book in front of you. My position in commerce through a business license to do business in commerce with respect to transactions, right? Remember that quid pro quo and the reciprocity. So these transactions to which this license is attached is transactions of land, right? Conveyance of one parcel of land from one entity or party to another. Okay, and that process that goes with all of that. And it's very complicated. So ask anybody who's done it. It's a complex process. So I won't go into it. But in the context of a corporation, okay, we have to do things called a market study, demographics and those different things to know where we want to put what we refer to as a box, right? A storefront, a location. So what would some of those things look like in relationship to jurisdiction? Okay, well, this office has jurisdiction under 28 USC subsection 1443, basically to reestablish zero, to point out everything that's below the line on the litmus test, which you have undoubtedly seen by now. I do have it in this presentation. If you don't have it, you'll have it here shortly. So knowing and understanding what a republic is in Congress, right? My position is on the private side is basically the same as the parliamentarian in the public sector side. Okay. So kind of give you an idea of how I know all of these things. It was just always my job to know. So do yourself a favor and be nice to your parliamentarian, because that's the same thing as saying be nice to me. So anyway, moving forward, you know what a meeting is, you know what a quorum is, you know what a preliminary impact assessment is, I'm sure by now. But in the private sector, those departments within the corporation, okay, those are referred to as R&D, or research and development, marketing, accounting, HR, human resources, shipping, payroll, and so on and so on and so on. You know those as agencies, okay? Practicing policy, which are referred to as guidance documents. Those are not law. Within the process, you can go down and you can see a case from the Idaho Supreme Court recently handed down, titled Peterson versus Peterson, where the judge goes through and basically explains why code and guidance documents, those things are not law. Those commissions they do not have legislative authority. Basically, the short version is what the judge is telling us is if we want to run for an office and we want to tell the people we're going to do the job, we're the ones bound to do the job. Okay, so what's the job? Well, The job in Congress is primarily oversight. So now the conflict that has transpired since the Trump impeachment is this conflict between a subsidy, right, and a stipend. Well, in so much as between the private sector and public sector, stipends in the private sector, that's our payroll. Okay. Subsidies are any contracts that we would engage in with state government or federal government to provide goods or services to, any branch for whatever the reason. Okay. And it could be anything from school bus parts to pens and pencils or a roll of toilet paper, as the context of today's situation would be more applicable. So unfortunately, what's been happening is when you have stepped into the emoluments of Congress, you've been met by what's called a bureaucrat, who's a member of the bar, typically 99 times out of 100. And they are paid lobbyists. Well, here in the state of Florida, we just recently passed law forbidding this practice, right? Lobbying is not lawful in the state of Florida. So I believe that's constitutional provision here in the state of Florida, Article 12. So you may want to refer back to somebody who's coming to you to lobby and tell them that they are wasting your time. And if they want to go make money, they need to go get a job the same as everybody else does in the private sector, and dismiss them, tell them to have a nice day. If they do not, you can feel free to call me, and I'll be more than happy to come and remove said person and allow you to get back to your day. So anyway, this person, okay, they're lobbying for these stipends, right? They're beneficiaries of their programs, right? They're literally a snake oil salesman, a confidence man, right? Constructing a confidence game, trickery, right? So basically, what's happened before you hit the door was we've been scammed, right? You've been had, right? So yes, you've inherited a mess. So have I. We have a mess to clean up. Let's get it done. Fortunately, that process is going to involve two things. Number one, resolution, and number two, repeal. Well, that's as easy as picking up a piece of paper and dropping it in the shredder. So as we go through and we look at a four-pillared mechanism in the private sector, again, the X and Y axis, the up and down, and then of course the left and right, and where the positives and negatives apply and why. So we see the advantage, profit, gain, and benefit, right? In my job, it was also having to manage all these benefits packages. The problem with that is I've always known I don't have standing to do that, because such package is not my property. It's the property of the person or persons who have entered into the agreement, the quid pro quo and the reciprocity. It's up to them to manage their benefits packages, not anybody else. So anybody tells you that that's true is, again, they're lying to you. So you can dismiss them with a certain satisfaction of knowing that you're not going to be scammed. So again, what we recognize in the Republic is the three-pillared model, right? Big corporations with those benefits packages. That's been a headache for me pretty much most of my working career. So here's the litmus test, okay, established on that coordinate geometry, knowing that the target in the code is 0, right? That's the target. We want no errors, no mistakes. So in the book, if you find those, you can go to section 405 in your Mason's manual and make any corrections, under that section. So, but here's where we're at, right? You are here in quadrant 1, right, to provide oversight of what's going on between the conflicts between these stipends and subsidies. Okay. So your job's just got a whole lot more complicated, knowing that these fourth pillar actors, right, many of them are arrogant. So dismissing them is not going to be difficult for you to do. What they are attempting to implement is quadrant 4, this kangaroo court problem. And again, according to my research, the only way to verbalize this, right, as emoluments of statutable plunder, because everything is always in the negative. It's literally death by never-ending circular virtuous arguments, right? You're never going to, if you've looked at the science, -1 will never equal 1, right? The cause of the thing causing is the cause of the effect, you know. So there are some people that you're just not going to satisfy. Just know it, accept it, understand it. So looking at their business model, quadrant number 4, okay? Let's look at their foreign business plans, those foreign emoluments as you're seeing them right now, those political arguments. Excuse me. The first one being domestic violence, stemming from the word advantage, which I'm going to show you this in a moment. And the other one, the next one, is doctors and vaccines. Here's the math substantiating or proving the negatives, right? So this is how they are still benefiting, right? -1 times -1 is 1, green. Just the same way you are in the private or in the public sector, right? In a lawful republic, right? These are referred to as, in history and law, as a star chamber. Those are not lawful here, right? The Sixth Amendment prohibits that. That's tyranny as, as defined, for lack of a better expression. So, excuse me. What impact do these foreign emoluments / markets have on domestic markets / domestic emoluments? So that's really what we're here to find out. So the 5-pillared between quadrants 1 and 4 of the litmus test, right? You see those positive ones, those greens? Well, that's the third pillar. Basically what this does is this is how they have targeted the judiciary, right? Well, this is how they're also denying justice. You see, there's a whole lot of negative here, right? So this is why there's no liberty, right? You can't even get to liberty interest. Too much negative. And even the judges are saying, you want us to sort all this stuff out? You're crazy. And quite frankly, I don't blame them. So, because this is a group effort, knowing and understanding that sole power of impeachment is in the House, right? So if you see anybody in position of emolument, okay, who is breaking the law, right? Sole power of impeachment rests with the House of Representatives. Trial of those impeachment rests in the Senate. Most of these are going to boil down to simple petition for articles of impeachment and an up and down vote. It's very simple. So the relationship to corporations in the private, which is what I am, okay, I'm a taxed for-profit subsidy, right? Those are here in blue. And these non-profit, non-taxed stipends, those are in red. There's your red flag, right? So they want all the benefits, right? That green, they want all those benefits down here in quadrant 4, but they don't want to provide the services. They don't want to do anything for that. Hence all negative, right? Or it's, again, never-ending virtuous arguments. I am entitled to this. No, you're not. No, you're not. Hate to be the bearer of bad news, but get a job like everybody else. So when we look at this in black and white, it looks innocuous, right? So when we look at the lack of a reference to Article 1, Section 9, Clause 8 in the legal dictionary, we can only go to the Merriam-Webster's dictionary of the archaic, the black and white, or corpse, dog Latin, right? Which is one of the reasons they've been able to hide all of this, right? So this presents clear evidence of the extensive efforts to hide the existence of these foreign emoluments as nonprofit religious organizations encroaching on and exploiting the First Amendment. It is what it is, right? because Congress shall make no law respecting the establishment of a religion. So when you apply color of law, as seen here, as evidenced here, the clarity of the fundamental alterations of government also becomes clear. Okay, so now we know where statutes, codes, rules, regulations, protocols, guidance documents, pleadings, word salad, and where all that other garbage comes from. So this was established in 1996, by the way, Title IV, right? That's what this is. This was when our government was fundamentally altered. This is the mess we're cleaning up, right? So the never-ending circular argument you're going to hear is, well, this person doesn't want to provide for their child. Well, I got some news for them. I was providing for my children long before any of these actors showed up. You know, my children, I don't know about you, but my kids left the hospital bought and paid for. So, but I digress. So, in the context of the way Ronald Reagan said it, government is not the solution to our problem. Government is the problem. So, again, with the whole more government, here it is, asked and answered, right? This is the true interpretation of domestic violence right there. So if a picture is worth 1,000 words, there's your answer. So, in so much as the Obamacare program, right, you see there are two versions of this, right? Because we have these, not just these deductible issues to deal with, there's also these endowment funds, right, that are taken in by donors. So, but it's all managed by this fourth pillar element known as the bar. Everything which is, quote unquote, a jurisdiction foreign to our form of government and unacknowledged by our Constitution, that's the language from the Declaration of Independence. That's where it applies as zero. So everything from the word emolumentum over to the right doesn't belong here. Now, hell, the whole thing doesn't belong here, right? Whatever, but this is how we are articulating those ill-gotten gains, right? I'm sure you've heard your grandmother refer to ill-gotten gains. That's those 5 pillars, right? That violates the First Amendment. Congress made a law respecting the establishment of a religion. Can't do that, right? Put government back in its box and clean up the mess, right? So, again, knowing that this is a group effort, Congress's job is to impeach this law, right? Get rid of it. So, again, how you want to do that, whether you want to do it through a joint session, whether you would like for me to come in and make the presentation for you, I'm more than willing, ready, willing, and able to get back to work. So, because I, for one, do not mind, paying my taxes and making sure that you guys are there doing your job. And, I'm not there to bust anybody's stones, that's for sure. So knowing and understanding that the two models, the first one was benefits, the second one here is highlighting the profits, right? And that's where we're at with the stimulus package right now, right? So as we're going through and we're trying to, deal with this whole coronavirus problem, the stimulus package, right? We have to highlight the profit side of this. So the benefits, right, become to the medical folks, right? And dealing with this monstrosity. So that's literally how I've modeled it. So just so you know the comparison and the contrast between the two, that's why. So, and of course, they're highlighted in red because we want to make sure that they're protected. So with respect to the foreign emoluments clause and what just went on in Washington, well, we now have court decisions, right, from the federal court. We've established supreme law and a minimum process. So let's start with this. And of these two cases, I'm going to highlight the one on the right, just a certain section of that to assist you with your legislative mechanism. So Because there was no decisions expressly denying immunity, the district and Maryland filed a motion that this court to dismiss the appeal, contending that there is no basis for appellate jurisdiction. In addition, because they filed a notice of voluntary dismissal of their claim against the president in his individual capacity in the district court after this appeal was docketed, they argue that the appeal is moot. The president contends, however, the district court's inaction on his motion, coupled with its order to proceed with discovery, had the effect of denying his claim of immunity and thus giving him the right to appeal immediately. He also contends that the district and Maryland's purported dismissal in the district court was ineffective because jurisdiction had already transferred to this court with his notice of appeal. With deferred ruling, on the district and Maryland's motion to dismiss the appeal pending oral argument. So, for the reasons that follow, which I won't go into them all, you can read this. This is posted. We now conclude that we have jurisdiction over the appeal with respect to the president's claim of immunity, and exercising that jurisdiction, hold that as a threshold matter. Right now we're getting into thresholds. The district in Maryland do not have standing under Article 3 to pursue the claims against the president in his individual capacity based on our ruling here and our ruling in Appeal 18-2486. We remand with instructions to dismiss the complaint with prejudice. So, stopping there, what does this say? This says that government has no standing against anyone in their individual capacity. So somebody claiming that they can send out an officer creating a fake warrant to go and do whatever, place the person under a condition of arrest, whatever that condition might entail. You can't do it. So you need to instruct, provide oversight, your executive agencies. The people in the private have standing against government because government has no standing against the people. Right? So in essence, when you talk about your position, your standing in law, it's just been mandated right here, right? The people have standing against government, not the other way around. So because the claims that the district and Maryland assert against the president in his individual capacity are identical to the claims they assert against him in his official capacity and are premised on the same factual allegations, our decision in appeal number, there's a number, also decided today and addressing the same standing issue governs the outcome here. We therefore hold that the district in Maryland do not have standing under Article 3 to pursue their claims against the president in any capacity, including his individual capacity. Accordingly, based on this opinion and our opinion in number 18-2486, we remand with instructions to dismiss the complaint with prejudice. Now that means get out of here and don't ever come back. Short version. So again, many of us were doing everything we can to try to make this as easy on you guys with expunging, right, with as many of these bad cases as possible, providing resolution, and that resolution in 99.9% of these cases is going to be the repeal, right? No replacement, repeal, because, as you notice, as you've no doubt discovered, any motion or measure that is adopted even by unanimous vote is void. It's void ab initio from its inception, not from the date it was declared unconstitutional, but it's from the date of its inception. So I hope that helps answer the question why finally putting to bed, right, the clarity of the foreign emoluments clause with why foreign emoluments have no standing, right, and where Congress comes from in relationship to why businesses are incorporated, right? Congress exists because of primarily a history. Congress exists primarily because of the merchants. You're there because of me. You're there because I put you there, right? To watch over the people, specifically my ex-wife and the kids, in my particular case, to keep them protected from these foreign emoluments. So now that we know these foreign emoluments have no standing, this Title IV and all of its benefits programs have no standing, this can now be repealed, right? So, and this does not just resolve the issues of this office, but the issues, I'm sure, of the constituent to which has presented you and directed you to watch this information. So, again, taking this from the Jefferson's rules, okay, standing rules and orders in the House of Representatives. So, touching the duties of the Speaker, he shall take the chair every day precisely at the hour to which the House shall have adjourned on the preceding day, shall immediately call the members to order, and on the appearance of a quorum shall cause the journal of the preceding day to be read. And you go from there. So, again, anybody has any questions on beginning an impeachment proceeding, please by all means let me know. I will forward all the appropriate documentation, copies of Jefferson's manual, whatever you need. And short version is here, Congress does not have the power to make law nor alter the fundamental law, meaning the republic, right? The word law is an acronym. It's derived from the original three jurisdictions: land, air, and water. Okay, so if you didn't know that, you know it now. So with respect to markets, domestic markets, I don't know what part of no do the Democrats in Congress not understand. No is no, right? The people are telling them no. The courts are telling them no. It's time for Congress to step in and say no. No is no. Okay, it's that simple. So, because Lord knows we want to go back to work. So thank you for watching, and I hope you found this content helpful. Again, if I can be of any further service, please see your constituent who has presented you this information for my direct contact information, and I'll be more than happy to make an appearance if necessary. So again, I thank you for watching, and have a wonderful day.